Hello, thanks for joining us for this second webinar in our rendezvous series on the Digital Markets Act and Digital Services Act. I'm Lara Natale, the Telecom, Media and Mobility Director at the Centre on Regulation in Europe, or CERRE. We are the independent Brussels-based think tank advancing top quality regulation practices in the network and infrastructure industries. We're also a multidisciplinary community drawing on perspectives across academia, regulatory authorities and industry. And I have the honour and pleasure of moderating today's session, which will focus on prohibitions and obligations in the DMA. You may recall that CERRE published its DMA recommendations in November, which was a few weeks ahead of the Commission adopting its proposals. And the same academic team behind those reflections also published their draft assessments of the Commission texts, having digested them. And these were presented by Alexandre de Strel in the first session of this series, which took place on the 19th of January. That session remains available via our YouTube channel, via our website, and the paper can indeed be downloaded from our website, which is CERRE.eu. To outline the structure of today's discussion agenda, we have Richard Feasey, Senior Advisor to the CERRE academic team, and Amelia Fletcher, Professor of Competition Policy at the University of East Anglia. They're here to give us context on the architecture around the obligations and the obligations themselves, including some comparisons on how, for example, the UK's Competition and Markets Authority has approached the same issues. We'll then triangulate with a transatlantic perspective from Howard Shelanski, Professor of Economics at the Yale School of Management. Then we'll be moving on to an industry panel comprising Amazon, Apple, and Booking.com, and I will introduce their representatives at that juncture. They will firstly provide their broad reaction to the EU text before deep diving into the prohibitions and obligations within the DMA. Our academics will close off with their key learnings from the panel. And we very much hope for interactive debate today, as we had in the first session. And we're delighted to notice that we have plenty of participants online on our website already and on our YouTube channel. Others will still be joining us. I think potentially the DMA represents rather a new way of doing regulation with its ex-ante measures and antitrust prerogatives. So it's understandably a hot topic academically and a hot potato politically. Therefore, we ran a poll on social media where we asked our audience for some top-line thoughts ahead of today's speaker discussions, and we have some charts to show you here revealing the results. So are the prohibitions and obligations in the DMA text the right ones? And I think the top-ranking answer was that more discussion would be needed. Do we have any other polls? Yes. Do the prohibitions and obligations in the Commission text go far enough, or should they be more detailed? And there, I think just edging ahead is again that more discussion is needed. Some think they're fair enough, and many think they should be more detailed. So lots to discuss today, but we're also, and we have some more charts coming up, but we're also keen to make space for a variety of further questions. And we'll make sure you can submit these via the Slido, which you can do using the hashtag CERREDMA or scanning the QR code that appears on the screen. And I will put questions to speakers as appropriate moments arise during the discussion. Again, this is the second event in a focused series. We will rendezvous again on Thursday, the 4th of March to look at institutional design and enforcement in the DMA. And on Monday, the 29th of March, we'll examine the DSA. The high-level closing session for this series will publish details on this in the coming weeks. We also finally warmly encourage you to sign up to the CERRE newsletter where you can get updates on these events. You'll find details in the box below if you're following on YouTube or on the CERRE website, CERRE.eu. Without further ado, let's get going. We have a very rich program today. It's over to Richard, first of all. Richard, hello. It would be great, if that's okay, if you could please kick things off with some of your analysis on the architecture around which the Commission has framed its prohibitions and obligations. That should give us good analytical context for further exploring the obligations themselves. Richard, over to you.
Thank you, Lara. So let me say a few words about the overall framework, and then I think Amelia will dive into the detail of the specific obligations. As I'm sure many of you know, there are two lists, first of all, of obligations and measures in the DMA proposals. Article 5, which has been described as self-executing. So these are obligations which the Commission assumes require no further explanation and no further maintenance on the part of the Commission or guidance. And I think the fact that the Commission assumes they are self-executing is one way of understanding the Commission's assumption about the relatively low number of people, level of personnel that they envisage as being required for this new regulatory body, 80 people in total. And if you assume that these obligations, by and large, will be implemented and take care of themselves, then that is understandable. Then there's a further set, a longer set of obligations and prohibitions and other measures in Article 6, and there is a job for the Commission. The Commission can provide guidance, but it appears that guidance is largely going to be provided in the context of an enforcement action. So once the Commission has found that a firm is not complying with the rules, the Commission can provide direction as to the steps they would then need to take in order to come into compliance. So that would be done in the context of an enforcement proceeding that was already underway. Perhaps the more interesting feature is that the firms themselves can also proactively ask for guidance from the Commission, and the Commission then has a period of time in which to provide it as to what measures they're supposed to take in order to ensure compliance. I think one interesting question we may come back to is what are the incentives on the firms to make those requests at the moment in the Commission's proposals? It's not clear, for example, that you would have any exemption from liability or from enforcement action or fines. So we might ask whether firms would have strong incentives to sort of bring their uncertainties as to whether they're complying or what measures they would take to the attention of the Commission, or whether it might make more sense to keep your head down and wait until the Commission themselves take action. My own view is I think some further thought on what the incentive properties of that mechanism are might be useful. Other things to note is there are no, unlike in other competition contexts, there are no opt-outs really. I mean, there are some very sort of exceptional circumstances under which firms may be exempted from the need to comply with these obligations, but they're very tightly constrained really. And they don't, in particular, they don't really think about the sort of objective justifications or efficiencies that might justify exempting a particular firm from a particular exemption given the particularities of its business model. So overall, I would say this list of obligations has an assumption that there's a low level of ambiguity about what the rules are, that it's pretty clear to people that there are not going to be circumstances under which the benefits of complying to these rules might be ambiguous or might be marginal, but that these are sort of fairly clear and confident rules that we can all assume are beneficial. I'm sure we'll get views as to whether or not those assumptions are well founded or not. There's also a process, obviously, for the Commission to add new obligations over time if it identifies them, and a further process of a sort of every 3-year evaluation of the DMA implementation overall, where I think we could also expect conclusions to be drawn about the effectiveness of the obligations, for example, and whether further changes should be made. So this will be and is anticipated as being a sort of dynamic process that has mechanisms for review built into it. I think there are two questions that I'd like to pose at the beginning of this discussion that we may come back to. So one is, as I've mentioned already, there is a lot of, or some weight at least, attached to this boundary between Article 5 and Article 6, and some obligations fall into Article 5 and others fall into Article 6. And I think we could ask ourselves, is that the right boundary to draw? It's not clear to me that an obligation, for example, to allow users to uninstall apps, which appears in Article 6, is actually a more complex obligation, or the kind that would require Commission guidance, than some of the obligations that currently appear in Article 5. So you could have a debate, I think, about which side of the boundary particular individual obligations might sit. But you might also, ask yourself whether there is another boundary to be drawn between, as the UK CMA is thinking about, I think, which is between what you might call prohibitions or obligations or rules on the one hand, and what the CMA calls pro-competitive interventions, of which the obligations in Article 6 to share data, for example, might be examples, because these are things that the firms are not prohibited from doing, and they're not forms of conduct that you want to stop. These are much more like traditional ex-ante regulatory market opening entry assistance measures that wouldn't otherwise be a normal feature of a market. They are essentially regulatory constructs that you want to put in place, much more complicated to design and to implement, and at the moment they appear in Article 6 as if they are in a similar category to many of the other prohibitions and obligations, but maybe there's another boundary to be drawn in thinking about how we organize the toolkit and the range of available measures to achieve the objectives. The second question, to my mind, is one that certainly at CERRE we've been debating for a long time in this, which is when you think about obligations and interventions, it's helpful to be really very clear about what your objective is. And in particular, whether the objective of these measures is to promote entry and competition in the core platform markets in which these firms operate, or whether it is to safeguard competition in related markets which otherwise may become dominated because of the leverage of power that market power that arises in the core platform services. And at least for me, it's not always clear when you look at the list of proposed obligations and proposed prohibitions in the DMA at the moment, which of those two objectives is being pursued. And my experience, at least of regulation, is that it's helpful to be very clear upfront about what your objective is, and to choose your tools and pick your rules and your remedies accordingly in light of the objective that you're pursuing. We might ask, I think, whether it is clear enough at the moment in the Commission's proposals as to what the objective is. That's all I wanted to say, so perhaps I'll pass to Amelia.
Thank you very much, Richard. That's really interesting and well noted on rules and tools. I just thought before we pass over to Amelia, it might be worth for our audience, in case you don't have the Commission text in front of you, my understanding is that Article 5 is the obligations for designated gatekeepers, and Article 6 denotes the obligations for the gatekeepers susceptible of being further specified. Great. So, Amelia, without further ado, it would be great if you could share your thoughts on Richard's remarks and also on the prohibitions and obligations themselves.
Thank you very much. I'm just going to share slide. I hope that's sharing okay. So Richard's, yes, talked about the architecture. I was going to focus on the obligations themselves, but of course there's 18 of them, and it's a very, very long debate to get into them in detail. So I'll probably be a little bit more on the architecture side as well. Just to highlight before we start that I'm a non-exec on the Competition and Markets Authority board. So I'm talking in my academic capacity, but I'm obviously very close to and sympathetic with what's being proposed in the UK. And actually, I think it's really quite aligned, or there are some obvious differences, but I think it's quite aligned with what's being recommended in the EU. There is one apparent difference, which is in the UK, the code is going to be the code of conduct for each firm will be done in a firm-specific way, developed participatively with the firms at the same time as the designation process is carried out. So that seems like it might lead to a much more firm-specific set of codes, whereas here we have obligations that apply to in the same way to all of the firms. On the other hand, I think it is worth highlighting that the intention is that the UK code would be based on some overarching core principles. And I don't think the CMA has yet said whether those core principles would be the same across all the firms, but I think they easily could be. And to help me think about that question, and also the DMA obligations, I put together this slide, which I promise I'm not going to talk through because it's very, very detailed. But what it does is it puts the proposed principles from the CMA's digital advertising market study. So that's the principles that the DMA developed, having only looked at the digital advertising market, so Google and Facebook, so not looking at all at Amazon, Apple or Microsoft or any other firm. And I put them alongside those principles, the DMA obligations. And what actually you can see is there's a very strong overlap in terms of the topics, the issues, the substance that is actually being addressed in these two jurisdictions. And I thought that was really informative, at least to me. However, when you do look at these look at them side by side in this way, there are other things that emerge, but that are worth highlighting. Whether they're concerning, I'm less sure. So the first thing that is fairly obvious, if you look in detail here, is that the CMA's proposed principles are broader than the DMA obligations, which are much more specific, both under Article 5 and under Article 6. But actually, that's not surprising, because the CMA's principles are intended to be principles, and you'd expect principles to be broader. You would expect that when the CMA goes through the process of creating the actual code on the basis of these principles, that they would get far more precisely specified, and they could start to look a lot more like the obligations in the right hand column without prejudging anything. It is also true that the CMA's proposed principles include a lot more modifying words like undue or unreasonably. I've highlighted these in red, or adverse effects. And whereas the DMA obligations essentially have no modifying words except for a tiny bit of saying you can't breach GDPR. Again, it's not obvious to me, at least, that by the time these principles have turned into actual codes of conduct for firms, and that process, is still to be gone through, that they will still have all those modifying words, which are useful in terms of ensuring you don't have unintended side effects, but do reduce the legal certainty and the self-executability of codes. So drawing on just looking at those, I asked myself some questions. Oh no, hang on, here we are. Oh, Yes, very good. Okay, so I think these are some of the questions that will come up later, and these are my kind of provisional answers. The first question is are the obligations too wide-ranging? And I think at least if you compare them with the CMA's obligations, and the CMA's been through probably a more detailed analysis, at least in the context of digital advertising, of the facts of what the problems are, and thinking through really quite carefully on the basis of evidence what they think their principles should be. They've come to a very similar position in terms of the range of issues. So I think arguably they're not too wide-ranging. Arguably, second question, are they addressing the right source of issues? It kind of looks like they are. Richard already raised this. This is a different question. It's not to do with the comparison with the UK, but is this line between Article 5 and Article 6? I think some people seem to have looked for that to be about the substance of what's being required. I think it is a purely pragmatic line. It looks to the question, can the obligation be framed in a way that is precise enough to be self-executable without further specification and without creating unintended side effects? Yes, I think you could argue about whether, everything is exactly on the right side of the line. And the next question, actually, Richard raised an Article 6 provision that he thought could be Article 5. I think you could also go through the Article 5 provisions, and some of those I would say are not entirely clear and unambiguous. So right now, yes, I'm not sure the line is clear, but I think it is a perfectly reasonable line to be trying to draw myself, and that the process that we're now going through of discussing and highlighting ambiguities, highlighting unintended side effects should help in creating greater precision and getting the right things, the right things on either side of that line. There's a debate about whether Article 6 is the obligations are too narrowly defined. So they have got, yes, quite specific quite quickly, things about ID services, etc. It all gets some of them are quite tightly defined. Is that a problem? Well, clearly it's good the more defined they can be if we want to be clear about what's required. Equally highlight that the DMA can add obligations via Article 10 following market investigations, so they can go broader again, potentially, even once the DMA is rolling. There is also, some have argued by comparison that some of the obligations are actually too broad, at least on the face of the legislation. Yes, they are quite broad. What exactly is self-preferencing? It can be many, many things. So I think that is true. On the other hand, there is this, obviously, there's going to be this process of further specification via Article 7. So I think that process should be really, really helpful in narrowing down, and hopefully that can actually look quite like the participative process that the UK is going to be going through in developing its code of conduct as well. So I think there's actually that whole process. The Article 7 process is also very well aligned, I think, with the kind of UK approach. The other thing I just wanted to highlight, because I don't think Richard did highlight it, in terms of all of these obligations, is they only apply to the specified activities in the UK, core platform services in the EU. So the obligations don't apply to all core platform services that designated firms are involved in, but only those that are themselves an important gateway. So if you think about Facebook, for an example, because they're not here, you might, and without prejudging anything, you might think that Facebook would be would have its the regulation applied to its social networking services, but might not have the regulation applied to its marketplace services, where it's obviously currently at least a whole lot smaller. And I think that also leads to the obligations being much more differentiated across different business models, and much more the specification process will generate a lot. I had another lot of questions, but actually I'm going to leave them for now because I think they are a bit replicative of what Richard talked about. So I'll leave it there. Overall, though, I'm really quite positive, as you might expect, about the DMA. But I also think that this process we're going through now is invaluable in terms of learning more, developing further, and I would expect to see a lot of refinement over the coming months.
Thank you so much, Amelia. I think it's really interesting. I mentioned in the introduction triangulation, and I think in this session we genuinely have, looking at the EU versus the UK versus the US, and seeing the overlaps and the distinctions, where we'll end up. Will one end up too wide, one end up too narrow? There's clearly a lot to play for. And with that in mind, Howard Shelanski, Professor of Law at Georgetown, good morning to you on the East Coast. Thank you for joining us from there. We understand that you can only be with us until for 1 hour, basically. So it's great that your main remarks are coming in now. It would be great if you could spend a few minutes talking us through what you see as the main US-based considerations, in particular on architecture, prohibitions and obligations, but I'm sure you might have a few remarks on the DMA themselves too. Thanks for being here.
Great, thanks very much, Lara. It's a real pleasure to be with everybody this morning. Just by way of brief disclosure, I'm wearing my academic hat, but I have provided legal advice to Facebook over time. So just want that disclosure to be out there while I make my remarks, in case you wish to discount accordingly. I'd like to start by agreeing with the questions and concerns that Richard raised, and also the very same questions that Amelia has asked in comparing the CMA's proposal with the DMA. I think arise for me as well. I think those are the right questions, and I think there are some very hard questions in line drawing that remain to be done. From the US perspective, if I were to put up a chart that was comparable to Amelia's, there would be absolutely nothing on the left side. We don't have anything that looks like the DMA. So we're in a somewhat different posture in the US when we look at this kind of proposal, which is, as Richard pointed out, really much more in the tradition of a regulatory model than the kind of doctrinal ex post enforcement approach we have in the United States. So let me say a couple of words about what I think the right analogy is, what I think the path forward in the US is going to be, and what the view from this side of the pond is. In the United States, we do have legislation that has been passed that feels very similar in form and style to the DMA. It's the Telecommunications Act of 1996. And it had a very similar kind of approach in that it was trying to facilitate entry and preserve openness of markets for new entrants into a set of services that had been provided by durable incumbents with significant network advantages. And there were a series of years during which the Federal Communications Commission prescribed a variety of regulations to ensure access and interoperability to incumbent telephone networks. In some sense, the model that we are looking at here in the DMA has some similarities to that. We do not, however, have any kind of broad competition-focused statute that would apply generally to the kinds of entities or digital platforms that the DMA is trying to reach. So we are still in the United States in the position of trying to either create this body of rulemaking from scratch, and the Federal Trade Commission has rulemaking authority. The scope of that authority is somewhat open to debate. It could be beefed up legislatively. But we're really at the very beginning of thinking about this kind of regulatory approach. And we're, I'd say, far behind both the UK and the European Union in terms of having a draft of such regulations out there. There have been proposals. I would refer you to the work of Fiona Scott Morton, Michael Kadish, the work of Harold Feld and Jean Kimmelman, and a recent article that Bill Rogerson and I have written that talks about the wisdom or feasibility of these kinds of ex-ante regulatory approaches to digital platforms. But I think it's safe to say that Europe and certainly the UK will be actually implementing these regulations well before we even have drafts of them circulating for thought and comment. And what that means is that the actual behavior of many of these companies is effectively going to be guided, I think, by the DMA and by events in the UK well before any kind of legal basis in the US. And I leave it to Kyle and James and others to comment on the extent to which, and Peter, the extent to which the behavior worldwide will be dictated by the CMA, but I suspect that much of the behavioral change will occur as a result of what's happening in Europe before we have any legal obligations imposed on the US side. There is legal development in the US that may borrow from or have some elements of the DMA. There's recently been legislation proposed by Senator Klobuchar that would tighten up antitrust law and strengthen it in certain ways. And I think there's some very good and interesting aspects of that legislation. But it's very much at the beginning of what promises to be a long and I think somewhat contentious legislative journey. And it also will not go nearly as far in terms of imposing obligations on incumbent firms as the DMA does. So that legislation will not fundamentally change the obligations, I think, of digital platforms and others that would be swept into the DMA. And so on the US side, many of the things, for example, an obligation to interoperate, an obligation to make data available, an obligation to be non-discriminatory in terms of access, bars on self-preferencing. All of those are things that are actually very hard to achieve doctrinally and through the courts under existing US antitrust doctrine. If anything, the antitrust doctrine over the past 20 years has evolved in a direction that is increasingly hostile to many of the kinds of provisions that one finds under Article 5 and Article 6 of the DMA. So for example, in the US, the obligation to interoperate is only allowable under the precedent of Trinco in really unusual circumstances. And one is absolutely free not to deal with a competitor. And in fact, one is even more free to deal with an entity that is not a competitor. So whether what one is trying to achieve is competition, is competition directly in the core service that a platform provides, or preserving openness for complementary kinds of services that would ride on top of that platform, that's a very difficult thing to achieve in the US doctrinally. In fact, there's even a decision involving Microsoft in the United States Court of Appeals for the 10th Circuit, which says that the desire to preserve profits for oneself is a perfectly permissible business justification for denying access to a rival or potential rival. Why do we care about a case out of the United States Court of Appeals for the 10th Circuit? Well, it is the United States Court of Appeals, so it's persuasive, if not binding, authority on other circuits. But very importantly, that decision was written by then Judge, now Justice Neil Gorsuch, and would be perhaps a signal of ways in which the court might proceed. And so the Supreme Court might proceed. A couple of comments about the DMA itself and some of the things that it that it tries to accomplish that I think would pose challenges, and I think in any legal development in the U.S. would raise real questions. I share all of the concerns and questions that Richard and Amelia raised, so I won't repeat them. I would note that there are some very hard questions that arise just in the definitions. For example, when it comes to sharing data, if you look in the definitions, the references to data and information, and I think a real question arises then, is there an obligation to share transformations of data into information that can be really valuable for how a platform operates? Indeed, could be, if you will, the secret sauce of its competitive advantage. A lot of innovation and thought goes into the transformation of data into information. Where is the line there in terms of what must be shared? One can see a very easy case, I at least think it's a fairly easy case, for saying that all data that is obtained directly from customers, that is in some sense raw data, that is not the platforms in any meaningful sense, but there might be shared ownership, I could perfectly see sharing that. And if a compendium of such raw data becomes, incredibly valuable competitive asset and a barrier to entry, one could even imagine sharing that raw data. But that data as transformed into information that can be used in strategic and competitive ways by the platform, that seems to raise incentive issues about sharing information, free riding, all kinds of things that are very embedded in the kinds of considerations that arise on whether or not we grant access, at least under US doctrine, and I think as a matter of economics are incredibly important. That data information line I think is very unclear. And I think there will be lots of challenges about what actually needs to be shared under the DMA. So I think there are a lot of hard questions to be answered there. Very related to that, I wonder about self-preferencing and how far that goes, and interoperability and how far that obligation goes when we talk about non-discrimination. To some extent, integration with a complement can be just a matter of exchanging information through an API. But beyond API, there can be deep levels of infrastructural integration that go beyond software into hardware that could give a service a real advantage to the extent that it runs on the platform. So if my proprietary complementary product works better than third-party complementary products because of degrees of information that go beyond degrees of integration that go beyond information exchange at the API, how much of that deep infrastructural integration do I either need to forego in order to maintain non-discrimination or share? So I think there are going to be a lot of very difficult questions that arise in actually implementing the DMA. Now, does that mean that we should try to work everything out in advance? I actually think not. We could discuss and face hard problems from now for the next century. At some level, putting the regulations into play and seeing how they work will be messy, it will be difficult, but a lot will be learned, and one can withdraw, change, modify on the fly, but at a certain point, the time for talking stops. You can never fully resolve all the questions, and the time for resolving the problems, in the course of implementation, as messy as it can be, may not be a bad idea. But I did just want to raise, I think, some real challenges that are likely to emerge going forward with the DMA from a U.S. perspective and looking at it through a U.S. doctrinal lens.
Thank you so much, Howard. Very interesting indeed. And I also listened with interest to some of your remarks towards the end of your intervention there on implementation challenges, which actually remind me quite a lot of what we saw in the CERRE recommendations on the DMA about this being a first phase and a new way of regulating and having to regularly assess and see how things were working and treat this as a dynamic piece of regulation. So thank you very much for that. And also a lot of remarks to date on varieties of business models. And with that in mind, I think we've gathered a very important variety of business models that we'd like to now open the industry panel with. I think their models span wide, both in their geographical reach and throughout the ecosystem of the platform-based economy. So we have great speakers lined up to communicate these. It's my pleasure to introduce Kyle Andeer, Chief Compliance Officer and Vice President of Corporate Law for Apple. Kyle, it's a particularly early morning for you on the East Coast. Maybe the sun has risen by now as it's setting here, but thank you ever so much for joining us at this very early hour for you. Peter Lochbihler, Global Head of Public Affairs for Booking.com, to give the European online travel company viewpoints, and James Waterworth, Director of EU Public Policy for Amazon. So again, very complementary businesses there, and we're very excited to have the three of you on our panel today to react to and of course ask a variety of questions we've prepared on obligations. A reminder to participants that the Slido is open for questions. If you'd like to, please let us know who you are. That could be very helpful. And if you have a panelist in mind for your questions. We do have a few questions coming in. I think I will maybe hold those just a few more minutes, if that's all right, until panelists have expressed their top line views on the DMA. And we'd like to kick off with this as we did in the first session, because I thought it worked quite well. So what we'd like to ask is if you could each please briefly capture the two main messages you wish to convey, one point of alignment with the Commission's thinking, and then what would be the key aspect of the proposal that you think needs reconsidering in negotiations. Following this, we'll zoom in on prohibitions and obligations and how these are treated in the proposal. Kyle, as you've woken up so early for us this morning, maybe let's start with you for this opening question. What would be yours or Apple's main point of agreement and disagreement when it comes to the Commission text?
Thanks, Lara, and good morning, everyone. It's a real pleasure to be here and to join you all virtually. I will say I am excited by the fact that I am sitting here in California and not in Brussels, where I understand it's quite cold and snowy. So you have my deepest regrets for that. So to quickly answer the setup here, I think in terms of things that I appreciate from the DMA, it is great to finally have kind of a concrete proposal on the table that we can all kind of debate and look at and assess over the coming months. So for months, years, we've heard a whole variety of different things that are going to be put on the table. And now we have something to kind of look at and say, okay, what are the economics and facts? Where does it guide us? What are our goals? And I understand, some of the goals right now are things like contestability and fairness. Contestability, I understand. Fairness is a little bit more difficult. I do think there are some other goals and objectives that need to be taken into account. Things like privacy, things like security, things like innovation, all of which are very important goals, not just in Europe, but around the world, that need to be kind of assessed and judged as we look at each one of these terms. I think I'm not going to sit here in California and pretend that the digital economy is a panacea, that there are no problems. I fully recognize that there are issues and challenges in today's digital economy. And I think there are some proposals here that will help address some of those challenges. Just to use an example, I think a challenge that we're all grappling with, both in industry and outside of industry, is how to assess, how to look at advertising funded models that rely heavily upon data. And I think, obviously there are some issues with past mergers, whether you're talking about Facebook and Instagram or current practices in that market, that competition law is ill-equipped to address. And I think there are proposals in the DMA that will help address some of those challenges. In terms of things I don't necessarily like, or that I have some concerns about and hope to get flushed out in the future debate, I think to some extent, as I read the proposals, you've taken a list of gripes and complaints that have been aired in various fora against Amazon or Microsoft or Google or Facebook or Apple, and put them all down in a list and said, we're going to take action to address all these gripes and complaints and apply this one set of rules to all 5 of these companies and perhaps others. I think that's a very rigid and complicated way of trying to address specific problems, perhaps with each company. And so I am very hopeful that we'll see a little bit more flexibility and thought as we kind of move through the debate. Again, I think there are some terms that make a lot of sense. I think there are other terms that, frankly, I've spent hours and hours and hours with business people and lawyers and advisors trying to understand how some of these terms apply to Apple and apply to our various businesses. And I can say, I haven't come up to an answer on most of those. Some of those are obvious. I can look at certain provisions like 5C and say, okay, I know who wants that provision. We've been dealing with that company for 4 or 5 years. Clearly they got what they wanted through the DMA. There are some others where I look at and I say, I think this could have a very significant impact on our ability to ensure that our platform is the most secure, private, and trusted in the marketplace. And there are things like 6C and 6F that I think could have a significant impact on user privacy and user security. So I have a lot of thoughts, but let me kind of pause there. I think that kind of sums them up. But I do appreciate forums like this and hearing people's questions and thoughts about this proposal.
Thank you so much, Carl, and it's great for us to hear your thoughts on the proposal too. It's much appreciated. Peter, how about you for the Booking.com?
Thank you, Lara, and hello to everyone taking the time to follow this panel, and pleasure to be on there. So the European Commission has no doubt tabled an ambitious proposal to keep digital markets fair and open. And that is an ambition that we firmly support and believe in, and we therefore welcome the DMA. We see the proposal as a solid starting point to regulate companies where there is no choice for consumers and businesses, in order to foster a more level playing field and to limit dependency where it exists. The reality is that a few digital companies have become so powerful that they are unavoidable trading partners for a large number of businesses. Often they control entire digital ecosystems, and this lack of choice can enable gatekeepers to engage in unfair practices and have sometimes made markets less contestable. And we therefore welcome the DMA's focus on dependency and platform entrenchment as being the right approach to regulating gatekeepers. If I look then at the accommodation market, the business that Booking.com is in, the situation is that both from a customer and a business user perspective, there is not one dominant way of reserving or distributing accommodation. There are many alternatives, not only available, but also being used by both sides. And that enables intense and pretty dynamic competition between a number of important players, including ourselves, Expedia, Airbnb, Trip.com, Google, and many more regional competitors, and not to forget, obviously, the direct online channels as well. Now, moving to the side of room to improve, if you want. On the aspect of designation, we believe the Commission's proposal should follow a more consistent approach on how it translates the objectives into effective criteria. An overemphasis on size criteria alone risks falsely capturing platforms that are large but not gatekeepers. And it also risks, at least over time, disproportionately capturing the homegrown European platforms, who naturally tend to be stronger in their home market than they are elsewhere. We are very supportive of the CERRE recommendations of late last year, which I believe very accurately translate the gatekeeper concept into simple criteria for designating them. And we believe the DMA would benefit from more strongly reflecting this type of criteria. More concretely, the DMA should more explicitly link the gatekeeper definition to user dependency, and in particular to lack of multi-homing on both sides of the market. The lack of multi-homing is, I would argue, the #1 defining feature of gatekeepers, as recognized by competition authorities, expert reports, and also in the support documents of the DMA proposal. Unfortunately, however, the proposal itself does not explicitly reference lack of multi-homing as part of the criteria when it comes to the rebuttal process and the market investigation. Secondly, and I will come back on that later in the discussion, I believe the proposal should recognize and be tailored more to the very different business models within the platform economy. This equally applies also to the criteria and the definition of monthly active end users, which needs to be differentiated by type of platform service. It just doesn't make sense to apply that same definition across the 5 different types of platform services. And last, to finish, I would argue the ecosystem orchestrator is an important criteria also, which was showing up in the CERRE recommendation that has been left out of the DMA criteria. I do think that it is relevant to pay attention to the capacity of a platform to control a wider ecosystem and to venture into new markets. It's an aspect that helps us identify where companies are heading, and an aspect that sets gatekeepers apart from simply large platforms. Thank you.
Thank you, Peter. I think I may have seen just before this panel as well that Booking.com may have published a blog post on your assessment of the DMA, which I'll also look forward to reading in more detail after this. So thank you for setting that out. James, over to you. I'm sure Amazon brings very important input to this debate, so thank you for being here. What's your overall take on the DMA? Maybe one thing you can align with more, and one thing you would contest. Thanks.
Thank you, Lara, and thank you very much to you and your team for the opportunity to contribute today and to this very good discussion. So in terms of how we look at the DMA and indeed the work that you have been undertaking for the last few months, firstly, we believe, as does the Commission, that the DMA should continue to assure that there is a fair business environment, that innovators and technology startups have opportunities to compete and innovate online, and that consumers have more and better services to choose from. That is clear. It should also, DMA should also be striving to make sure there are no barriers that prevent companies or consumers, whatever their size, taking advantage of the single market, a key element of European policy, and indeed of innovation. It should encourage innovation and ensure it doesn't stifle it. One angle that we look at this from is as a retailer. Retail is omni-channel, and so from that perspective, it's somewhat surprising to see the narrow scope of the DMA, as there's no lock-in in retail. In terms of some of the specifics, it's already been mentioned, Article 5C of the proposal, which talks about allowing business users to promote their offers and contract with parties outside of the regulated service or marketplace. And this raises concerns, and let me briefly describe what they are. Every year, just before Christmas, Europol publishes its golden rules for online shopping. And buying from trusted sources is the #1 Europol golden rule. And we know that trust is something that is very hard to gain and easy to lose. So this article risks being bad for consumers, and particularly in light of the fact that this proposal is being debated alongside the Digital Services Act, which rightly seeks to ensure that people have high trust in digital services, needs to be looked at carefully to ensure it is workable and workable for a retail environment. Finally, on the CERRE analysis and the work that you and your team have been doing over the last few months, I think the team rightly recommends that any so-called gatekeeper should be able to defend business practices and potentially avoid some obligations by illustrating that they are beneficial, that their business practices are beneficial. And this would, for example, be on the basis that they are pro-innovation, and there are a number of social and economic benefits from their practices. CERRE also points at the fact that we need to have a flexible regulatory approach in a fast-changing environment, and that talks to the idea of case-by-case assessment. It is going to be difficult to get around the idea that we need case-by-case assessment of the different business models, different products, and indeed different practices and situations. Finally, and on exactly that point, it's necessary to consider the difference and the differences between the different industries as well as business models. Retail is different from software, retail is different from search, and both the CERRE analysis and the proposal should take this clearly into account. Thank you.
Thank you, James. Very clear, and of course, as CERRE will also take note of your feedback on our proposals. Thank you very much. I think before we go deeper into questions on prohibitions and obligations themselves, we luckily have a lot of good questions coming in via the Slido, and I'm going to privilege the one addressed to Howard first, noting that Howard will have to leave us shortly in a few minutes. So Howard, if this is all right, I will take the question asked to you, and then maybe if you could give us a couple of key takeaways from what you've heard so far, that would be great. And thank you again so much for being here, understanding that you have to leave early. So Frederik de Backer from Telefonica asks you, as you suggested, Howard, the fine-tuning of remedies will be a kind of exploratory process. How could this be set up to achieve a collaborative process between regulators, regulated firms, and other market participants without turning into an endless gaming of the system type of a process?
That's a great question, and I wish I had the answer to it. I do think that there are a couple of models out there that one might look toward. To the extent that what we're going to really have is a DMA that sets forth some self-executing obligations, as opposed to being what is effectively a statute that will really be, as James suggested, largely applied case by case. One possibility is to look at the model of negotiated rulemaking that is used in a number of industries, certainly used in the United States, where stakeholders across the board related to a particular market or set of services will come together and define what is actually necessary in terms of remedies for access, for interoperability, for integration, all of those things. And a set of backstops could be articulated in the event that that negotiation doesn't succeed. But you could have some kind of outcome where a set of carrots and sticks is set up by the agency as the defaults. It will not please really any side. And then a set of what really is necessary in terms of access and interoperability and data sharing in a particular market or a particular set of services could be established and put on the table and could become self-executing. I don't know if that's an easy process. I mean, I'm sure it's not an easy process, but it might be better than a lot of sort of one-off kinds of solutions that effectively game the system or leave a lot of murkiness. I do think it's going to be very hard to come up with one-size-fits-all solutions under Articles 5 and 6. And so figuring out how, to James' point, and Kyle's point, the heterogeneity of the different kinds of entities that will be regulated here can lead to a set of obligations that is relatively fit for purpose for those different kinds of entities. A negotiated rulemaking process or something like that, or a negotiated remedies process that sets some defaults might be a way to proceed. But I do think it's going to be very challenging, and the every 2 years sort of reviews that the draft contemplates could wind up swamping sort of any effective articulation and implementation. So this will be a real challenge going forward. And I think by way of takeaways, my takeaway is really the same. There, I think, are some very good principles. It may be in the end that a set of very high-level basic principles get implemented first, with a lot of details being worked out over time. But the implementation problems will be such that I think a lot remains to be seen about whether the DMA will be sort of an aspirational document that sets forth sort of the kinds of conduct we would like to see and not see, or whether it really becomes a self-executing set of understandings about what firms must and must not do. But there's certainly some work ahead of us.
Thank you so much, Howard, and thank you again for joining us today. And
thank you. Pleasure to be here.
To continue the conversation with you. Thanks again. 20 more questions. Let me take a couple. Many are not addressed to a specific panelist, so I can jump in. But there's one here from Giulio Piccone do the panelists believe that the Commission's experts will be able to understand the different business models in timely fashion and be able to impose the different enforcements required? And then there's another question on variety of business models, which I think this might be a good point to bring to our industry panelists too. Don't we need a more targeted approach to the obligations, as we see in the UK and in Germany, to account for different business models? Article 7 seems insufficient in this respect. Would anyone like to have a go at one of those? Kyle?
Sure. Let me take the last one first. I do think, you know, this differences, the differentiation that Howard just mentioned, and the fact that you have 5 companies that are very different from each other, from Apple to Amazon to Microsoft to Google to Facebook. These are very different companies in very different markets. And so I think having a process and a framework that allows you to engage each company in the markets and its business model and the way it's approached those markets is very important. And so I do see things in the German legislation that recently passed and in the UK proposal that allow for that sort of more tailored, more engaged process. And I think that makes a lot of sense. Because I do think, you know, looking at the current proposal, it's very difficult to understand how a lot of these apply to a particular business. And in order to have that conversation, I'll harken back to something Richard said at the beginning. You know, it is a hard question about whether you go in and seek guidance. And I think having a process set up where it's much more kind of engaged and having some back and forth would help.
Great, thank you, Kyle. Anybody else on those questions? Peter, I see you muted.
I would just add one comment on top of what Kyle just said, which is I think, you know, the Commission has experience from other regulated industries of case-by-case assessment. I mean, when we look at telecoms, for example, which is more homogenous than what we're debating under the DMA, the Commission has acknowledged the need for case-by-case assessment of situations. So if that holds true for something that is more homogeneous, I think it becomes even more necessary for a wider set of product, services, and models.
I'd be happy to come in on the question of targeted approach, which seems to be broad consensus, if I read that correctly, on this panel anyway. And I think there are 2 path towards that objective. There is the German and UK path, as I would call it, with and Amelia outlined that before, with a more principles-based approach, which then gets applied and executed by authorities case by case. My fear with the Commission proposal is that it's a bit neither here nor there. I think it generalizes issues that we all know where they're coming from, where they originated. It generalizes them to some extent. To me, that bears a risk of not allowing for effective enforcement for those situations where there are actual gatekeeping issues, and at the same time being over-inclusive and bringing in companies and behaviors that are not problematic. This is the problem that I see. So I think it's either principles-based and then executed by authorities, or a much more prescriptive and more detailed, tailor-made and differentiated way of looking at the conduct. I'd be curious to hear Amelia's views on that one, because I think you started going down that route before.
So I think that there's kind of 2 ways in which that question could play out. One is in the actual definition of what's in Article 8, Article 5 and Article 6, and then in the process of the specification process for Article 6. Clearly, we don't want anything in Article 5 that is ambiguous or going to give problems when applied to kind of the wrong business model, the business model for which it wasn't originally intended. So I think that is an area where all of the firms that may be touched by this regulation really should be shouting and saying, look, this doesn't make any sense for us. In Article 6, obviously there is this process of specification. So I think there the question isn't, does it as it stand cause problems for us? It's, does it can we see this being specified? Can we not see this being specified in a way that we think would be appropriate, or is it so inherently problematic? So I think there's the question of the designing those, and then there's a separate question of, do we think that once we've got this regulation in place, do we think the Commission is going to be capable of having the debate with the firms about the specification process, which has actually got a very short time period associated with it? I think the Commission's way of doing it is to put a lot of work on the firms. So the idea is the firms have to come in and say, this is how we propose, these are the measures we propose would be effective in achieving this obligation. I think that's quite smart from the Commission's perspective. The question then is, how are they going to assess it when firms come in and say, we think this is going to be effective? My hunch is they'll probably, for practicable reasons, say, okay, if you think that's going to be effective, let's run with that and see if it actually is effective. And so maybe this is going to be an ongoing process of review of the effectiveness of these measures. I mean, overall, I think it's complex, but it's complex in two stages.
Richard, I think you'll just come in. You're on mute. Richard, you're on mute.
Sorry. I mean, I agree with a lot of what's been said. The way I think about it is, first of all, I think the DMA needs to give firms the incentives to engage constructively in the dialogue and to disclose information early and expansively. I'm not sure that's quite there at the moment. So I think having that conversation in the context of enforcement proceedings, for example, is not a great context in which to have that dialogue. And I remain skeptical as to the incentives on firms to volunteer that conversation at the moment in the DMA, but I think there are ways that could be created. But then there's a very practical point, which is there needs to be enough people on the other side of the dialogue to be able to process that information and deal with it in a confident fashion, because the danger I see is in a resource-constrained commission having these conversations. The tendency will be to be skeptical, I suspect, and to say, well, we're just going to default back to the obligation is as it says on the face of the directive, and or the regulation. You just have to do that, and we're not going to give you much further comfort. So I think we need to have incentives for the firms to engage in the dialogue in the right way. And we need to have resources and capability on the other side of the dialogue to be able to then deal with that in a reasonable time frame. I take Howard's point about negotiated rulemaking, but my experience is that just takes a long time. And I think one of the features that the Commission is certainly looking for here is we need to have obligations biting fairly quickly, if at all possible.
Thank you, Richard. Can I take this opportunity to announce that anybody having issues watching on our website can watch along on YouTube, where I believe there isn't a crackling issue, and you'll find the link in the event description on the event page you're looking at right now. Let's not miss the opportunity to dig deeper and look at when should prohibitions and obligations themselves apply, and we'll continue to take questions via the Slido, but mindful of time, let's go to prohibitions and obligations themselves. Panelists, it would be great to hear from you, and we are touching on this. I think what's been really good so far is that even in the broad where we're at on the DMA as the whole, obligations are coming in a lot into that. But how flexible do we see the specification process as being, and what should there then be the process for a designated platform to seek an exemption? So, for example, efficiency or objective justification. We're talking a lot about the Commission's Article 5 for designated gatekeepers versus the Article 6 for the gatekeepers susceptible of being further specified. Is that a distinction that really works? And then we have a DMA text from the Commission whereby obligations can be added, but apparently not amended or removed. Is this a problem? Howard has already given views on this, but it would be great to hear from our panel. Peter, let's start with you this time. What are your views there?
Was it to me, Lara? Sorry,
I just thought we'd flip the order a bit.
Yeah, no, happy to come in there. So on, I believe that the market investigation route would seem to be the right basis for both adding and removing obligations. What I would like to add then is that, and that comes back to tailor making and differentiating the conduct obligations in more detail. I would argue that new obligations that result from a market investigation can then only apply to gatekeepers in this specific markets that have been investigated and not per se applied horizontally, because that would bring us back to what I believe is one of the issues with the proposal of taking problematic behaviors out of their context. And if I may add one or two examples very quickly, one is coming back to 5C, the anti-steering provision, where I mean that basically boils down to the question who gets remunerated for their services, and is that a one-time or an extended type of remuneration? And I would argue once a platform has been remunerated for acquiring a client, I would argue yes, there should be ways for the business partner then at the right time to bring their own offers. However, and we all know where this is coming from, but apply that now to a platform that provides products or services where very often refundable rates, if I speak about accommodation here, is very much common practice, and secondly, very much in the consumer interest. So then you would basically entirely legitimize free riding and undermine one business model for the benefit of another. If a business partner is by an EU regulation allowed to encourage a customer to cancel a booking made on our site, get refunded and do it directly with them, because then we have invested and are not remunerated at all. So I think this is, in my view, the clearest example of what I would call an absurd effect of a conduct that is taken out of context.
Thanks very much. James, over to you, though perhaps I might take the opportunity to equally introduce a question specifically to you coming in via the Slido about further explaining, if you can, the no lock-in in retail point that you mentioned earlier.
Sure. Well, there is a business that has been built, our business has been built around ensuring that small businesses can sell around the world. In the EU, for example, in 2019, businesses selling on Amazon exported 9 billion euros worth of products and services, and they can and do sell on multiple services. So this has been a very effective way for brands to sell direct to consumers and to compete with large retailers of all sizes on the same terms as those large retailers of all sizes. So if we were to be looking for a specific problem, it doesn't seem to be there. It more seems to be that many brands who would like to get into classic retail are unable to get into classic retail. So they're unable to get distribution in the first place. And let me give you an example of one of the slightly strange situations that this proposal throws up, which is that in 2020, Amazon launched in 2 European countries, in the Netherlands and Sweden. And in both countries, our revenues will be small, having just launched, and we compete against much larger retailers who operate both first-party retail, online retail, offline retail. And so there will be some slightly strange incentives where they are not bound potentially by the same constraints as Amazon would be bound by, even though they are much larger players. So the lock-in, to the extent it exists, is more about what is the opportunity for brands and merchants to sell to clients around the world, not just in their home territory. And we are of the view that the new models, one of which is the one we've been investing in, that we have an incentive to drive, is exactly what allows small firms to do that.
Great, thank you, James. I don't know if Richard and Amelia wanted to jump in with anything here. There is, I did have a second round of questions that we don't have lots of time to address, but I think would be really good, because then we really do get into the sort of great detail of the obligations. So Kyle, maybe before we do that, could we have your view on the questions we just addressed?
Sure thing. I think, you know, in terms of looking at each of these terms and asking whether there's an opportunity to raise objective justifications or other sorts of arguments for why a particular term should or should not apply to a platform, I think I started it from trying to understand what's the goal of each term. So what is the harm the commission or the term is trying to address? And so once you kind of have that understanding, you can then say, okay, let's take 6C or 6F, for example. Those are very much focused on, hey, do you allow third-party app stores? How much access do you allow to an operating system or even to a device? And, you know, from an Apple perspective, I think, you know, our focus is very much on, there are some other issues there that must be taken into account before you just kind of rigidly apply that. And I think Richard makes the point that you may have an agency that's not fully staffed or fully comprehends what those trade-offs are. And that's a very real concern when you're talking about a model that's been built around privacy and security. You know, we have provided a lot of access to our platform over the years in terms of creating a technology platform that allowed developers to create just amazing apps. We also have a process to make sure that we vet those, to make sure that they're being used in an appropriate and trusted way. And so to suddenly say, well, we're going to just throw open the doors and not only allow third parties to kind of step in the shoes and decide what apps are available, but we're also going to say you have to throw open the doors to the entire technology platform without any regard to safekeeping, things like privacy and security. That's very concerning. And so I think that trade-off is something that's that needs to be taken into account. And, you know, obviously I'm focused on it from an Apple perspective, but I think in listening to Peter and to James, I think they're grappling with it as well, which is, again, when you look at a particular term, some of these may just simply say, okay, I understand how to apply that. Others are going to take a lot of work and engagement back and forth with a particular agency or regulator. And I don't see that opportunity in the text. And I'm very concerned about some of the things that Richard said around, do you, even if it's in the text, do you have the people equipped to kind of make those judgments and second guess kind of a business judgment on that? That's troubling.
Thank you, Kyle.
Lara,
Yes.
if I may, very, very briefly, because you asked primarily, I think, around exemption based on things like objective justification. And what I want to emphasize is not directly an exemption, but it's about the rebuttal process. In some of the supporting documents, there were comments that the Commission would expect the rebuttal process to only in exceptional cases to allow, you know, deemed gatekeepers to basically make the case out. And that is something I find worrying, because the quantitative criteria are simplistic. They are size-based. They do not, in the first place, talk about dependency. And this is why I believe it's, you know, if we accept the quantitative criteria as a first level filter, then it's even more important to really build dependency multi-homing into the rebuttal process and make that a real meaningful, you know, path for companies to make their case.
Thank you, Peter. It's interesting that the rebuttable presumption came up a lot in the first webinar as well. Right, mindful of time, I would like to go to the last round of questions, and I'm going to weave in within that a couple more coming in from the Slido. So panelists, if you would like and are able to address these as well, that would be fantastic. And then we'll move on to Richard and Amelia for some closing remarks. So on their obligations, we're really interested in understanding whether you think the same obligations should apply to all designated platforms or be tailored to the business model, or a mixture. Or we can word it as, should we be reading Articles 5 and 6 as applying equally to all business models? That's really the crux of the matter here. Some questions coming in from the Slido on this basis. Helena asks what the panelists think of the allocation of well-established harms in competition policy, MFN clauses, for example, and self-preferencing, if we're talking about Articles 5 and Article 6, respectively. Marcus asks whether we believe the DMA will effectively manage to regulate anti-competitive behavior and hold big players accountable. And we also have interoperability has come up several times, and we have a question from Julia to Richard, which maybe you can address as we're concluding, Richard, which is that a requirement of inter-platform interoperability is missing from the DMA, despite strong calls in favour of it. Richard, what do you think of such an obligation? Smorgasbord there of questions. But James, let's come to you first this time.
All right, can you just clarify which one you'd like me to address? I was noting the list, but
in particular, there's a lot. I appreciate that, but I think in particular whether or not the same obligations should apply across all designated platforms, and whether we should read Articles 5 and 6 as applying equally to all business models. That's really, I think, the crux of the matter in these quite interlinked articles within the same chapter of the DMA text.
Yeah. Now, I mean, I think that as I said at the beginning, we need to look at this case by case, given the different business model, the different products and services, the different, what will be going on in different countries. And so there are risks in terms of what other political and social objectives can be compromised if we don't do this case by case. Let me just maybe give one topical example to illustrate this and the importance of innovation, as it would apply to us. So I hope that we would all agree that a product that a retailer might offer, all retailers might offer, like hand sanitizer, given the current environment, is something that is a useful innovation for, not just for consumers, but indeed for society at large. And if the rules were so broad and so broadly applied that they were to prevent the introduction of a product such as that at a moment like that, I don't think that would be useful for customers of a particular store or for society at large. So I think that's an example of how absence of case-by-case specification can result in losses in terms of innovation. There can be large-scale innovations. Another example would be voice assistants. Voice assistants, for those who've used one, they are something which allow an entry point into computing, particularly for people with disabilities who may have trouble with vision or trouble with movement. And I think we need to be very careful about potentially foregoing whether smaller innovations like introduction of a hand sanitizer product into a retailer, or major long-term innovations like voice assistants. And unless we look at these rules in a case-by-case manner, we risk foregoing those beneficial innovations.
Thanks, James. Kyle, how about you?
So which of those would you like me to tackle? Anything in particular?
At this point, I will leave it up to you, but would love your understanding of whether or not 5 and 6 in particular should be read equally across all business models. And if you have time to tackle any others, that would be great too.
So I think, as I said already, I don't believe that you can take the obligations in 5 and 6 and apply it to, depending on how you count them, 20 or 30 different core platform services as it's currently defined. I think that is far too ambitious an exercise, and you really need to take into account not just the product itself, but also kind of the business model that supports the business that's competing in that market. So take operating systems, for example. There is a model that we adopt, which is integrated with our devices, very much focused on selling devices. And we sell that obviously for a price. There's another model which is based on providing a operating system for free, which is supported by advertising. And that is then licensed to third-party device manufacturers. Those are two very, very different business models with different incentives and different issues. And I think you need to take those into account when you're looking at some of these terms and prohibitions. And I'm just using that as one illustrative example. You can go down and through each one of these core platform services and say, wow, there are some issues with this specific product, and there are these companies participating in this market, and they have different incentives and different approaches to the marketplace that you have to take into account. So rigidly, I'm particularly concerned with Article 5 because that is so-called self-executing, as if it's obvious what the issues are. As I read that, we have had, as I said earlier, hours and hours, days and days of debate about what exactly that means. Article 6, at least there's an opportunity to have some clarity, but I still think there's a lot of confusion there.
Kyle, Peter?
Yeah, I gave one example before with anti-steering 5C as an example of a conduct taken out of context, having unintended consequences. To add a second example, which is more the lack of specificity, I believe that the self-preferencing clause in 6D, to be quite blunt, will not do much about Google self-preferencing in travel, something where we have been on the receiving end for many years. I would expect the way it's written right now, we would see an extension of Google Shopping type discussions for another 10 years. Without much impact. There was one question about the effectiveness from someone in the audience. So that is my response on the shortcomings in that regard.
Thank you very much. We are about to run out of time, but before we do so, Richard, Amelia, your main takeaways from this panel. I personally find for our CERRE reflections, this is how we like to work, having strong input from business representatives and how they really see the measures. What are the key learnings for you been? There have been so many more intelligent questions coming in from the Slido that it would have been great to take that maybe we'll discuss at a future occasion too.
So if I go first, I think that what we've really heard a lot of is concerns that the obligations don't respect the different business models of the companies. I think that those points are really well made. On the other hand, I personally would be incredibly surprised if the Commission backs away from the obligations process that it has gone down. I can't see it moving back to where the kind of CMA approach. I think it sees it as a pragmatic approach in the face of companies that have huge resources and the inclination to kind of argue points with them kind of on every point, and therefore they need to get these obligations down on paper, agreed kind of upfront. So much as I agree with the economic concerns, I think practically, I just can't see the Commission changing its view. So I would think that what we really need to do is think about how, in the context of an obligation framework, we can nonetheless reflect and recognize some of those concerns that have been raised. So how can we make sure that Article 5 really is written in a way that does allow self-execution? How can we make sure that the Article 6 provisions really do work in the specification process, really does work in the required way to enable it to reflect, so far as is possible, the different business models, recognizing, of course, that it only applies to the core platform services that really have the important gateway power. So I think there's a lot more work to be done on the law, but I just can't see the overall architecture changing. So I think the more granular, the detailed comments that we can all provide to try and help, but within that framework, would be is kind of where we should be going, is my hunch.
Thank you so much, Amelia. Richard, a quick wrap up from you too. Thanks.
Well, I mean, I very much want to echo that. So I thought it was a very helpful discussion. I think it's very important to remember what the Commission's proposals are reacting to. And what they're reacting to is a concern that the existing competition mechanisms just take too long. And so I think any attempt to improve the proposals, which I think there are plenty of opportunities to do so, needs to provide mechanisms which ensure that questions get resolved quickly. And that anything that looks like it will introduce a mechanism whereby the Commission will get bogged down, will take a long time, consume a lot of resource on the Commission's part, I think will get pretty short shrift. Mechanisms that give firms an opportunity to make their case against the background of a deadline or a default, I think would have sort of more chance of getting an audience. So, and I do think, I am sympathetic to the idea that there might need to be more space to avoid sort of egregious errors here. But I think we need to find a way to catch those errors in a way that allows the Commission nonetheless to feel that in the majority of cases it can sort of move forward without getting bogged down. The other thing I think is that I very much agree with Howard that learning by doing has much to commend itself. I'm not sure the current DMA framework is flexible enough to allow the feedback loop from learning by doing to work quickly enough. So for example, I'm not sure you need a market investigation to modify an existing obligation. You might need one to introduce a completely new obligation, but I'm not sure you need much more.
Thank you so much, Richard. We've learned a lot by doing today, I believe. Thank you to all our great speakers for being here across time zones at various points in your day. We'll take a lot away from the discussion. We'll hold more conversations on the DMA. Please do consider signing up to the free CERRE newsletter. We reconvene for our next DMA rendezvous on Thursday, the 4th of March. We'll talk about institutional design and enforcement there. So those of you asking questions on that, there'll be the chance to deep dive on that too. Confirmed panelists and details will be available on the CERRE website too. We hold a range of other events on various tech, media, telecom topics. We'll be looking at broader ways of regulatory oversight for the digital economy, for example, on the 23rd of February. We'll be talking about AI and liability in March, so hope you can join us for those too. Many thanks again to all of you for joining us today. We look forward to follow up and wishing you a great evening. Thank you again. Bye for now.
Thank you.